All right, good morning, everyone. I'm sorry, I am personally late. There was quite a traffic jam this morning, so I hope no one else was in it. Allie Fannin, Greater Richmond Bar Foundation. I see a lot of familiar faces, and I don't know if it's because I've seen you before or you've attended one of these trainings, so if I repeat information you already know from 2 other trainings, sorry. We are welcoming today David Constein and Sam Otero as our presenters, and we have a great program, a lot of materials, so I will be quick. The Greater Richmond Bar Foundation is the sponsoring organization of the General Counsel program. We do other things to connect lawyers to pro bono service opportunities, and we're very thankful to have you interested in connecting to the nonprofit sector. We do this through the Pro Bono Clearinghouse, which you may have volunteered before through, and it is a great service for legal requests for advice in transactional matters. And the General Counsel program that you are interested in is just going to be a different take on serving nonprofits with more of a long engagement of a year and looking at how can we spot issues before they happen. Real quickly, today is the 3rd training of a series of 5. The next one is October 25th, which will be during our triage launch and annual pro bono celebration. I definitely encourage everyone to come to that one. 3 to 5 are the training sessions, and 5 to 7 is the celebration with food and drink. We will have some great speakers, and the training will be done by Bill Gray on tax issues. We also have a change of date of the November training. Originally, I believe it was November 9th, and now it will be November 16th due to a conflict of the trainer. And that's going to be on commercial activities and other things related to nonprofit engaging in contracts. So we are right now in the midst of getting the final applications of the nonprofit clients. We have had quite interest, 45 originally, and we will only be selecting 25 maximum and perhaps less just to keep this pilot program manageable. So we appreciate it. And on October 25th, we're going to be getting some of your interest in missions and other areas to see if we can match you to a meaningful relationship with the client. So thanks again. And here we go. I'm going to turn it over to Sam and David.
Thanks, Allie. Good morning, everybody. My name is David Constein. I'm a lawyer with Troutman Sanders here in Richmond, and I'm in our labor and employment group and have been there for quite a while. I'm happy to be here with you all today to provide some training relative to your role as general counsel to whatever nonprofits you determine to service. The primary purpose of our presentation today is to help you issue spot with respect to employment law issues that may arise in the context of your providing general counsel advice. So I'm going to go through and give a brief summary of some of the major laws under federal employment law and state employment law, and then Sam is going to provide kind of a deeper dive into some isolated questions. So I want to begin with the granddaddy of all employment laws, which is Title VII of the Civil Rights Act of 1964. I'm sure that you have all heard of Title VII. It prohibits discrimination based on race, gender, national origin, citizenship, ethnicity, religion, and it also prohibits retaliation. Employers are prohibited from imposing adverse actions on employees in the context of hiring, firing, all promotions, discipline, every term and condition of employment based on a protected classification. The first question that you need to ask in terms of your role is whether or not Title VII even applies to you. Title VII only applies if you have 15 or more employees who work in 20 or more calendar weeks in the current or preceding calendar year. So it's often a surprise even to some of my smaller clients when I inform them that they're not covered under Title VII. And it's usually a good surprise for them. But that doesn't get you totally off the hook. By the way, you look at your payroll to determine whether or not an individual is employed for the current or preceding calendar year. Independent contractors don't count. That could be the subject of an entirely different seminar, which is whether an individual is classified properly as an independent contractor or an employee. But for purposes of our discussion today, it's 15 or more employees for 20 or more calendar weeks. Even if you have a client that has less than 15 employees, there is still protection for the employees against all forms of invidious discrimination. In Virginia, we have the Virginia Human Rights Act, and that applies to employers who have more than 5 and less than 15 employees. And that covers basically the same categories as Title VII, except it also includes a prohibition against discrimination based on marital status. The remedies under the Virginia Human Rights Act are more limited than under Title VII. They're limited to 12 months of back pay, but it's still something that you don't want to have to deal with. Once you deal with the remedies, of course, you've gone too far. But that's a law that you need to be aware of. You're not totally scot-free if you don't have 15 or more employees. As I mentioned, the protected characteristics under Title VII are those that are commonly understood: race, sex, color, religion, national origin. The issue of sex discrimination can be a little vexing, and you need to be aware that in the context of sex discrimination, there are issues that arise with respect to sex stereotyping, transgender discrimination, and also discrimination on the basis of sexual orientation. The law is pretty clear, except in one circuit, that sexual orientation in and of itself is not a protected characteristic under Title VII. So discrimination based on a person being gay is not illegal under Title VII. It's not illegal under the Virginia Human Rights Act. I'm not suggesting that anybody discriminate on that basis, but if you are concerned, and the way these things come up is, one of your clients will want to terminate an employee, and you kind of go through the checklist of what are the protected characteristics, and inevitably somebody will tell you that an employee is gay. And although that may be interesting, it's not legally significant with respect to discrimination as to pure sexual orientation. The law is not completely clear, however. The Seventh Circuit has ruled that sexual orientation is protected and ultimately probably will make its way to the Supreme Court. Also, with respect to sex stereotyping, you cannot discriminate against someone based on stereotypes about how they should conduct themselves based on their gender. The classic case of sex stereotyping was Price Waterhouse versus Hopkins. I don't know if any of you all have heard of that case, but that was a case where a woman was attempting to make partner at Price Waterhouse. She was very masculine. She was very aggressive. She wore, clothing that was not considered to be feminine, and the partners at Price Waterhouse decided not to make her a partner on that basis. The Supreme Court held that that was illegal, not because of her sexual orientation, but because she was being sexually stereotyped. And that is a form of sex discrimination that is recognized in the law, and that has bled over into the protection of individuals who are transgender. And so the law is pretty clear, although I saw yesterday that the Trump administration was taking a different position. The law has been pretty clear in the last 5 to 10 years that transgender individuals are protected under Title VII. Cultural traits are not protected. There was a case recently where an individual had dreadlocks, refused to cut them, and was fired. The 11th Circuit held that that was not race discrimination, that cultural traits associated with race are not protected under Title VII. Again, these are issues that will come to you in the context of your client asking you about whether or not they can make certain employment decisions and whether they need to tread carefully because of someone's protected character or certain characteristics. There are two forms of discrimination under Title VII and also under the employment discrimination laws. The first is disparate treatment, and the second is disparate impact. I doubt seriously that you will ever encounter a disparate impact case, but I'll tell you what it is. Disparate treatment, of course, is just treating someone differently than others who are not in the protected class, and treating the ones who are not in the protected class more favorably. That can happen in the context of individuals, it can happen in the context of groups, and again, although you'll never have to deal with it, I'm sure in your role as general counsel to one of these nonprofits, it can also be the basis for class action. Again, when your client comes to you and asks about whether they can terminate or discipline or do something, one question you'll always want to ask is, how were similarly situated people treated? You know, again, when you go through the checklist of protected characteristics, and if the person who's the subject of the adverse action is in a protected class, you'll want to know, how were similarly situated people treated? Were other people who engaged in the same sort of conduct treated as stringently as your client wants to treat them in this particular case? And similarly situated means, did they engage in the same conduct? Were they supervised by the same supervisor? Just a litany of questions that you want to go through to determine whether or not an individual is similarly situated. And that kind of points out it's important to be consistent in the discipline that your clients will want to mete out to their employees, because the first thing an employee who is subject to discipline will think of if they're in a protected class is whether or not people outside that protected class were treated differently. So that's obviously significant. A disparate impact case involves a situation where you have a facially neutral policy that has a disproportionate impact on a protected class. For example, requiring a high school diploma for everyone you employ. That doesn't make sense for individuals who might work in your maintenance department, and that could have an adverse impact or a disproportionate impact on people in a protected class. So it's possible that you would have that situation arise. In my 30 years of doing this, I've just only had a few disparate impact cases. I have had a bunch of disparate impact issues, and so it's something to be aware of. Sexual harassment. Obviously, it's in the news quite a bit these days. Sexual harassment is prohibited under Title VII, and there are two basic forms of sexual harassment. The first is quid pro quo harassment, and the second is hostile work environment. With respect to quid pro quo harassment, that's the most common that's the most obvious, but I would say actually the least common form of sex discrimination, at least that I encounter. That occurs when someone blatantly makes job benefits contingent upon performing sexual favors or having a romantic relationship. Also, withholding job detriment, saying I won't fire you if you perform sexual acts. So that's pretty straightforward, pretty clear. Quid pro quo harassment is obviously prohibited. A common problem that does arise in the context of quid pro quo harassment is when you have supervisors who have a consensual relationship with subordinates. And that's a question that I think maybe you all could get. That could certainly happen, where your client comes to you and tells you that one of their supervisors, one of their executives, has a relationship with one of their subordinates. That's obviously a problem that you want to avoid. Many clients, many employers have policies that prohibit any kind of intimate relationship between employees who are in a direct line of reporting. I would encourage you to not allow that, because it always leads to problems. Unless they get married, the relationship is going to end. Inevitably, something will go south. An employee who is in a relationship could easily claim that even though it was consensual, they were actually coerced into having sex with their supervisor. That can lead to a big lawsuit. This is a problem you want to avoid. There's also a problem involving favoritism, because the employees who are not engaged in the relationship may claim or assert that because they're not willing to play ball, they're not getting the same kinds of job advantages that the employee who is in the relationship is getting. So it's fraught with problems, and unless you just can't avoid it, a subordinate should always be removed from a supervisor with whom she's having a relationship. Again, there are whole seminars on these topics, so I'm just going to go through them quickly so you'll be able to recognize what they are. Hostile work environment. It's not only in sex, it can be based on race, age, disability, religion, ethnicity, national origin, the whole gamut. There can be a hostile work environment claim based on any form of harassment. This is a pretty commonly misunderstood topic. Obviously, sexual harassment, hostile work environment, everyone understands, but I have received countless questions about whether or not there's a hostile work environment just because a supervisor is being mean to an employee or being brusque or not giving them certain assignments or creating any sort of friction in the workplace. People always assume that it's a, quote, hostile work environment. A hostile work environment, however, is a term of art. It applies in the context of the discrimination laws, and it is required in order to have a hostile work environment claim that it be based on a protected characteristic. You need to be treating someone hostilely because of their sex, because of their race, because of their protected characteristic. General meanness is not a hostile work environment. A hostile work environment claim also is a pretty narrow claim. You look at the frequency of the claim, the duration of the allegations, the duration, how long it's going on, how frequently it's going on, how severe the conduct is. Generally speaking, in order to have a hostile work environment claim, there must be severe or pervasive conduct. So typically isolated incidents can't create a hostile work environment claim. And so you will encounter these types of issues, I presume, after they've already occurred. You'll deal with a hostile work environment by and large when your client calls you and say that somebody has claimed that they're in a hostile work environment. So you'll need to look at how pervasive it was, how severe it was, and then determine what type of corrective action needs to be taken. I said that isolated incidents typically don't give rise to a hostile work environment, but if there's any kind of touching, if there's any kind of groping, if there are, nasty racial comments that are made, those in and of themselves can give rise to a hostile work environment. And when you get these kinds of claims, even if they don't legally rise to the level of a hostile work environment, they should be investigated and appropriate corrective action should be taken. You don't want to let these things fester. So regardless of whether it meets the legal standard, I would investigate. One thing that's very important with respect to hostile work environment claims and harassment generally is to have a policy. You want, and I'm sure you all know this, but anti-harassment policies are critical for a lot of reasons. Number one, they give the employee an opportunity and an avenue to complain, and they should be written, and you can find them on the internet, but they should be written in such a way that the employee has an option or an opportunity to go to someone who is not their direct supervisor, because often the direct supervisor is the person who is engaging in the harassment. So you want them to be able to go to either the HR director or if you don't have an HR department because these nonprofits are small, go to the CEO or the COO or designate someone who can receive these harassment complaints. The policies are also important because they can provide a basis for an affirmative defense under the law. If there's a line of cases known as Farragher and Ellerth, and they basically say that if you have a policy that is designed to provide appropriate corrective action, I'm sorry, does anybody need any dishes? I just kind of noticed it. But in any event, if you have a policy that is designed to provide appropriate corrective action for an employee who complains, then if the employee does not take advantage of that policy, then you have a defense under Title VII, the ADA, whatever. That all provides an affirmative defense to a harassment claim. Employer liability under Title VII is all based on agency. It's based on agency theories. A supervisor who engages in hostile work environment harassment, unless you have a policy that the employee fails to follow, will basically provide strict liability for an employer. However, a co-employee who engages in harassment or hostile work environment will not provide a basis for liability unless the employer knows about it and fails to act. And that's one of the reasons why when you get these complaints, even if they don't amount to a legally cognizable claim, you have to investigate. You have to interview the people that are important. And I always think it's a good idea to inform the complainant who has made a claim of sexual harassment what the results of the investigation have been. It's good to have an interactive process with the complainant so that they feel they're part of the process, so that they're invested with you, so that they feel their rights are being protected. And that goes a long way to preventing, an EEOC charge or a lawsuit. Whoops. A significant aspect of all employment discrimination law is retaliation. In my opinion, this is the most dangerous cause of action that exists in employment law because it applies to individuals even who have no valid claim. If an individual makes a claim of discrimination, if they oppose an unlawful practice or a practice that they believe is unlawful, if they participate in testifying in an EEOC proceeding, or if they support someone else's claim of discrimination, it's very important that that your clients take no adverse action against that employee, because even when someone complains that they have been the victim of discrimination or a hostile work environment and they're wrong and there's been nothing of the sort, as long as they have a subjective belief and an objectively reasonable belief that discrimination has occurred, then they're protected from retaliation. And to make it easy, I would not even go through the subjective objective analysis. That's what I do when I'm defending litigation. But in your role, if someone makes a claim of discrimination, then they're on a higher level in terms of protection. And so you need to treat what the employer does with kid gloves. You need to step carefully because retaliation claims are fast and furious. They're prevalent. They come all the time when people who have no valid claim believe that they've been retaliated against. The way to prove a retaliation claim on the employee standpoint is to establish that they've engaged in protected activity, that they've suffered an adverse action, and that there's a causal connection between the protected action and the adverse action. One thing that is important to keep in mind is that temporal proximity is usually the way that employees prove causation. And there has to be a very narrow gap in time in order for an employee to prove temporal proximity. So if you have an employee, the Supreme Court has said, for example, 2 to 3 months is too long a gap between a complaint of unlawful discrimination and an adverse action for a court to infer that there has been retaliation. So when I'm advising my clients and they want to terminate somebody, and I ask them, have they made a claim of discrimination at any point in time? And they say, oh yeah, they made one last week. I say, well, let's not take any action now. But if they continue, because my clients would never do anything unlawful, these are obviously people who have engaged in some type of improper activity in the workplace. If they've screwed up once, they'll screw up again. And so give them rope, wait 2 to 3 months, and then take action after they have improperly not followed a work rule or whatever. So if you give yourself some space and give your clients some space, you can rid yourself of employees who are not performing without concerns that you'll face a valid retaliation claim. So the next law, that was Title VII in 10 minutes. The next law is Section 1981, and that is a very dangerous claim. It protects against race discrimination. The law actually says that all persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts and it's not in there, but this is the critical part, as white citizens. So every person shall have the same right to make contracts as white citizens. This is the Civil Rights Act of 1866. So it protects against race discrimination and it protects against ethnic discrimination. The reason that this statute is so dangerous is because, unlike Title VII, there are no damages caps. In Title VII claims, if you have between less than 50 or less than 100 employees, it's 50,000. Less than 200, it's 100. Less than 300 or less than 500, it's 200, and over 500, it's 300,000. Those are the caps for compensatory and punitive damages. They don't apply to back pay. Under Section 1981, there are no damages caps at all, and so the possibility for punitive damages is governed by general federal law, and compensatory damages the same thing. In addition, unlike Title VII, which has a very short statute of limitations, just so you'll know, in order to pursue a claim under Title VII, an employee has to file a charge of discrimination with the Equal Employment Opportunity Commission within 300 days of the unlawful action. And if they don't do that, then their claim is barred. So it's a very short statute of limitations. Then once you go through the EEOC process, an employee has 90 days from the date the EEOC concludes its investigation and issues what's known as a right to sue letter to file their claim. So very short statute of limitations. Section 1981 has a 4-year statute of limitations. So this is a law, the substantive law of 1981 is the same as Title VII in terms of its prohibitions, but the remedies are much more difficult for employers to deal with. The next law to mention is GINA, the Genetic Information Non-Discrimination Act of 2008. That law's been around for 10 years. I think I've maybe dealt with it 3 times. You don't see it very often, but it basically prohibits discrimination on the basis of genetic information. It commonly, when it does arise, it arises in the context typically of people who don't want to hire an employee or want to get rid of an employee because of whatever genetic predisposition they might have, which will increase health insurance premiums. So employers are worried about the genetic predisposition of certain employees. They're concerned that it will raise their health insurance premiums, and so they don't hire or terminate those employees. Again, I doubt that you'll encounter it, but examples of it are Huntington's disease, cystic fibrosis, other genetic diseases that you don't hear about all that often, but which can be extremely expensive from an employer's standpoint if they have to deal with that. The next law is the Equal Pay Act of 1964. That prohibits basically the same thing as Title VII. You cannot discriminate against individuals on the basis of compensation if they are performing a job that requires equal skill, effort, and responsibility. There are exceptions to that law, and those are listed: a seniority system, a merit system, a system that measures on piecemeal by quantity or quality of work, and then the most important exception is any factor other than sex. That's an extremely significant exception that you need to be aware of because it allows you to take into account the prior experience and qualifications of individuals. So, I mean, I had a case recently with a nonprofit where they had lost their CEO, who had been the CEO for 15 years, had a wealth of experience, had been paid a very significant salary. They hired an individual who was a CEO. It was her first position as a CEO. She was performing the same job as the individual who had left, but the client wanted to pay her less. The question was whether or not they could do so under the Equal Pay Act, and the answer was yes, because the individual who was being hired had significantly less experience and significantly different qualifications than the individual who had left the position. So that would be a defense under the Equal Pay Act, even when employees are performing jobs that require the same skill, effort, and responsibility. Under the Equal Pay Act, the remedies are also different, just so you'll know. The Equal Pay Act allows for liquidated damages, which are double damages, and attorney's fees. Title VII, of course, has the whole panoply of compensatory and punitive damages. The next law is, that I'll mention is the Age Discrimination in Employment Act. That amazingly protects individuals over the age of 40. I'm wondering if at some point Congress will raise that, but I haven't heard any discussion about it. It applies to employers who have 20 or more employees. So it's not the same rule as Title VII. Title VII is 15, ADEA is 20 or more employees. That is the threshold. And it prohibits any kind of age discrimination or age-based policies. You cannot have a maximum hire age. In other words, we're not going to hire anybody over the age of 50. And you can't have a maximum retirement age. That's a commonly misunderstood concept. People think that you can have a maximum retirement age or a mandatory retirement age, and you cannot do that except in certain industries where there are bona fide occupational qualifications, none of which will be applicable here. There's another law that is ancillary to the ADEA, known as the Older Workers Benefit Protection Act. And this is a law that is not in our slides, but you definitely need to be aware of this in your role as general counsel to nonprofits. It's the Older Workers Benefit Protection Act. And that is the law that says, among other things, that in order to obtain a valid age discrimination waiver when you terminate an employee and you get them to sign a release, in order to get a valid age discrimination waiver for people who are over 40, they need to have 21, I'm sure you all have heard of this, they need to have 21 days to consider the agreement and then 7 days to revoke the agreement. They also have to be advised to consult an attorney, and the agreement has to be written in plain English. So that all needs to be actually written out in the agreement that they sign. There are a million forms that you can find. You just need to be aware that whenever you're dealing with somebody over 40, these requirements apply in order to get a valid release. So if you're going to pay somebody 6 months severance, you want to make sure that you get a full and complete release, and in order to do so, you need to jump through these hoops under the Older Workers Benefit Protection Act. And people that are in your position that don't practice employment law, I can see this would be a trap for the unwary, and so you need to be aware of that. If there is more than one person terminated at the same time, if there's a group termination, then you need to give the individuals 45 days to consider the agreement. The 21-day rule doesn't apply, and you need to give them 45 days to consider the agreement. And you also need to provide I call it a matrix, but a chart that identifies all of the individuals who were considered for termination and were not selected, their ages and their job title, and all of the individuals who were considered for termination and who were selected. And that arises typically in the context of a reduction in force, but a reduction in force could be 3 people. It could be 2 people, and you still need to jump through the hoops that the Older Worker Benefit Protection Act mandates. And one thing on that point, that doesn't mean that you cannot fire them for 21 days. In other words, you don't have to give them 21 days to consider the agreement and keep them employed during that 21 days. You can say, hey, I'm sorry, your employment is terminated. Here's a release. It's our standard document. We're going to give you 3 months of severance or 30 days of pay. But in order to get that, you need to sign this document. You have 21 days to consider it. So the employment can end at that moment. They just get 21 days to consider the document, and they don't have to take 21 days. They can sign it right there. And that doesn't invalidate the agreement. All right. The Americans with Disabilities Act. The Americans with Disabilities Act is the broad, sweeping federal law that prohibits disability discrimination. The threshold number for application of the ADA is 15 employees, like Title VII. It would have been easy if they'd made them all the same, but they didn't. So you've got 15 for Title VII, 15 for the ADA, and 20 for the Age Discrimination in Employment Act. and you calculate that the same way as you do for Title VII in terms of looking at the payroll. If you have a nonprofit or any client that has less than 15 employees, again, there's a state law that applies, which is the Virginians with Disabilities Act. And I didn't mention it, but if you don't have 20 employees under the Age Act, the Virginia Human Rights Act applies. So you have state laws that apply that fills in the holes. By and large, there's some exceptions with respect to all of Title VII, all of Age, and all of the Americans with Disabilities Act. The Virginians with Disabilities Act prohibits discrimination against individuals with disabilities. It also has lesser remedies. And one thing that's important to know about the Virginians with Disabilities Act, because I assume some of you all will be working with nonprofits who have less than 15 employees, you've heard of the duty of accommodation, which we're going to talk about, that exists under the Americans with Disabilities Act. The Virginians with Disabilities Act also imposes a duty of accommodation, but there is a bright line in the Virginians with Disabilities Act that does not apply under federal law. If the cost of the accommodation that an employee is seeking, if you have a client with less than 15 employees, is more than $500, then it is presumptively an undue burden for the employer to have to provide that accommodation. So that's a nice bright line test that the Virginia legislature has provided as guidance to the employees that doesn't exist in federal law. So a disability is a physical or mental impairment that substantially limits one or more major life activities. It also includes individuals with a record of such impairments, so if they have a history of hospitalization for disabilities or a history of cancer, then they are protected under the ADA. It also prohibits discrimination against individuals that you regard as disabled, even if they are not disabled. And so that is basically the perception of the employer. You used to see it arise in the context of individuals who are HIV positive. They didn't have any symptoms. They weren't limited in any major life activity, but employers were concerned about hiring them because they were concerned about contagion. Those employees were still protected under the ADA even though they didn't have any disability because they were regarded as being disabled. The Americans with Disabilities Act was amended in 2008, and it was amended in order to eliminate the impact of certain Supreme Court decisions that had greatly narrowed the application of the Americans with Disabilities Act. In particular, for example, the Supreme Court had decided that if you used mitigating measures like eyeglasses or medication, and that rendered you normal, not disabled, then you weren't entitled to protections under the ADA. The amendments eliminated that. The amendments greatly expanded the types of disabilities that are covered under the ADA. And my general rule of thumb is, unless it's a common cold or the flu or something that is pretty obviously not a disability, then I proceed under the presumption that it is disabled, and I advise my clients to treat the individuals as if they're protected under the ADA. It's just it's more conservative. You'd rather do that than have to file a motion to dismiss explaining to the court why it's not a disability under the ADA. This particularly comes up with temporary impairments. Things like broken legs, sprained ankles were never covered under the ADA prior to the amendments. But now, if you look at the particular break, and you look at the severity, and you look at whether there are any complications, if there are multiple surgeries, then that can bleed over into coverage under the ADA. So you have to be very careful whenever you're dealing with somebody who is injured or ill to determine whether or not they're covered under the ADA. The major life activities and being substantially limited, the major life activities are very broad. You'll see them at the bottom. Caring for oneself, performing manual tasks, breathing, sleeping, eating, all of those things covered under the ADA is a major life activity. Stress, anxiety, depression, all covered under the ADA. I'm not going to bore you with a war story, but I had a case recently where the employee claimed that she was covered under the ADA because she had stress from her supervisor. She didn't have stress anywhere else. She just had stress from her supervisor. Thankfully, there are cases that say that is not a disability under the ADA, but that's one of the only things that it's not protected. The duty of reasonable accommodation is something that you may encounter. You know, an employee with, multiple back surgeries needs, some kind of ergonomic fix, need a standing desk, something like that. If an employee has an injury or illness and they seek some form of accommodation, then an employer has a duty to provide a reasonable accommodation. A reasonable accommodation does not mean that you have to provide the specific accommodation that the employee is requesting. You can provide whatever accommodation you come up with as long as it's reasonable. For example, an employee who has had multiple back surgeries, can't sit for a prolonged period of time. That employee, wants a chair that costs $2,000, and your nonprofit can't afford that. That's too difficult. It would be an undue burden. What can you do? What can you offer? You can offer frequent breaks. You could offer any other type of accommodation, frequent breaks, letting them change positions, letting them, walk around. Whatever you come up with, that can be an accommodation that you can provide. Had a case where an employee claimed that she had stress in the workplace, clinical depression, anxiety. She wanted to transfer to a vacant position for which she was qualified, which is an accommodation that an employer is required to provide. If there's an open position and you have an employee who is covered under the ADA, you have an obligation, if they're qualified, to put them in that vacant position, with some exceptions. The position that she wanted was to be the secretary to the general counsel. And if I had put her in that position, I would have been shot. So that was not a position we were going to offer. But we found another position which she hated, but it was still a reasonable accommodation, and that's what we offered. Ultimately, she quit, but we had offered reasonable accommodations to her. We didn't have to put her in the position that she wanted. Sometimes, I don't know if this will come up for you guys, but sometimes you have situations where an employee poses a direct threat because of a condition that they have. It could be an infectious disease. I had a case once involving MRSA, where the employer was very concerned about the employee with MRSA coming into the workplace and infecting other employees. If you consider an employee to be a direct threat for whatever reason to themselves or to other people, then you have an obligation to provide an individualized assessment to determine whether or not that individual really does pose a significant risk of substantial harm, and that's the test. And inevitably, you have to have a doctor who either examines the individual or examines the job description and their medical records and tells you whether or not this individual meets that standard. Even though things may seem like common sense, you can easily violate the ADA by assuming that someone poses a direct risk or a direct threat of substantial harm if you don't get a medical opinion. Obviously, individuals need to be qualified in order to be covered. They have to be able to perform the essential functions of the job. These are all in your outline. I'm not going to go through all the requirements for essential job functions, but this is all part of examining whether or not someone is protected under the ADA. When someone asks for an accommodation under the ADA, you need to engage in the interactive process, what's known as the interactive process. You need to sit down. You need to tell your client that they need to sit down with the employee and actually have a conversation about what the employee wants and what the employer can provide. That is a requirement under the ADA, and the failure to do it can result in a violation of the law. Very often, people always minimize other people's problems. And so employers inevitably will get a complaint about an employee's, illness or injury. They think it's minor, they don't think it's an issue, and they don't want to deal with it. If they come to you and they tell you about this, and you recognize it as potentially being covered under the ADA, then you should counsel them about the interactive process and what they need to do in order to ascertain whether or not an accommodation is required. As I mentioned or alluded to, undue hardship is a basis for refusing an accommodation. By and large, it's a pretty tough standard to meet. You can meet it easily if you just have the Virginians with Disabilities Act and you have that $500 threshold. But if you're covered by the federal law and you have 15 or more employees, an employee wants an accommodation, if it's a question of money, and you're going to be dealing with the nonprofit, so the rules will be a little bit different. But if it's anywhere within the realm of reasonableness and it requires an expenditure of $1,500 to provide a standing desk or some other type of ergonomic device that might enable a ramp for a wheelchair, those are the kinds of things that you have to do. And you won't be able to claim it's an undue burden simply because it might cost $1,000. It's a different question when the employee wants to be accommodated and that accommodation will disrupt the operations of the company. For example, you have an administrative assistant with severe carpal tunnel syndrome, and she wants as an accommodation that her job be restructured so that she doesn't have to type. That is not something that you need to do. That's an extreme example, but there are lots of examples of employees who want accommodations that would actually disrupt the operations of the company, and therefore they won't have to be provided. And it would be an undue burden, for example, if you only have 2 people on a shift and one person wants to go on another shift and the other individuals on the second shift can't move to the first shift. That may be an accommodation that you just cannot provide. That won't happen in the nonprofit world, but you get my drift. If it disrupts the operations of the company, it's not a reasonable accommodation. I have some examples here. Installing an elevator, obviously that's too expensive. Installing a ramp, you would need to do it. Holding an employee's job open for a significant period of time. Typically, that is something that is required. Allowing an employee to have unpaid leave while they recuperate from illness or injury is typically something that an employer must do. My general rule of thumb is 5 to 6 months. And in the nonprofit world with a small employer, if you have 17 employees, that number probably can come down, but you have to look at the nature of the job and the impact on the operations, and then determine how much leave you can provide reasonably. But I can almost guarantee you whatever you think is reasonable, you need to add some time to it, because the courts are very liberal in the way they construct this. So that's a real difficulty, and I get those questions all the time. What do you do with an employee that's going out for surgery and needs a period of time to recuperate? How long do they have to keep their job open? I'll get to it, but you're probably not going to be covered by the Family Medical Leave Act, which applies to employers with 50 or more employees within a 75-mile radius. So you're going to be dealing with smaller employers who have to wrestle with, how long do I have to keep this job open? And that's a vexing question, and it wouldn't surprise me if you get that more than any other employment question.
David, can I jump in for a second? Yeah. Another thing to keep in mind with the ADA is that the ADA also prohibits employers from treating people who have disabilities less favorably than those without disabilities. So while David's given you some good examples of certain accommodations that might be an undue hardship for the employer, you have to check with these nonprofits about their precedent. Have you allowed somebody to work from home for 2 days a week because their mother was ill and they needed to be home to make sure she had her medications? That employee didn't have a disability, and you allowed them to work from home. If the disabled employee then comes to you and says, I want to work from home for 2 days because of my disability and it'll help me, then you need to really consider, are they in the same job? Does this precedent make it almost mandatory for us to treat the disabled employee as favorably as we treated the non-disabled employee, et cetera. So particularly with nonprofits who are generally pretty sympathetic people, you really need to look at the precedent and how they treated people in the past and make sure you're not bucking the trend.
Right. So that's what Sam has talked about is disparate treatment discrimination in the context of the ADA. And that goes back to what we talked about earlier with respect to people who are similarly situated. But Sam raises a good point because they may not be similarly situated. You may have an employee that you just provided an accommodation to for another reason that doesn't have anything to do with the disability, but the law would view that as a similar type of similar situation. Similarly situated individuals who needed some form of accommodation, you can't treat an individual with a disability less favorably than the person who doesn't have a disability. And that's also true, I don't remember if we've gotten to it, but pregnancy discrimination, did I mention that? I might have flown through that. Pregnancy discrimination is not covered under the ADA, but it's the same kind of analysis. In other words, the Pregnancy Discrimination Act of 1978 is part of Title VII, and you cannot treat individuals who are pregnant less favorably than you treat other individuals who have similar types of temporary disabilities. So it's kind of a weird law. It's not like you can't discriminate. It's just you can't treat them less favorably than other individuals who have similar temporary disabilities. But my rule of thumb is don't discriminate. You don't need to parse through the language of the statute and try to determine whether or not this falls with, can you treat this person less favorably because you can't identify somebody with a similar disability that you've provided this benefit to? I don't even tell my clients that that's the law. We just deal with non-discrimination on the basis of pregnancy, and that is a much safer way and a much more prudent way and a much more holistic and good way for the workforce to treat your employees. But pregnancy discrimination is impermissible, and the rules really are virtually the same as they are under other forms of Title VII. I don't think you'll have too many light duty situations, but if you do under the ADA, the general rule is you need to put a person in a vacant position if they're otherwise qualified. If you have a light duty position that is vacant and you have an individual who is disabled and wants an accommodation, then you need to put them in that position. You don't have any obligation to create a light duty position. You don't have any duty to cobble together job functions from other positions to create some form of light duty. If you have a position that's available and it would be light duty, fine, but you don't have any obligation to create light duty. That is not an accommodation. So that's something I really didn't talk about, but you don't have to create a job for people as an accommodation. Accommodations, you can restructure jobs, you can put them in vacant positions, you can give them unpaid leave, you can provide a desk, but you don't have to create a position that doesn't otherwise exist. With respect to medical exams and inquiries, you can make inquiries about two individuals as long as it's job related and consistent with business necessity. In other words, if it relates specifically to how they're performing their job and whether they can perform certain job duties, you can make medical inquiries or even require medical exams, but you can't just generally ask questions about their health. So if someone, has multiple sclerosis and you ask them, how does your MS affect your ability to do this particular component of your job? That's okay. But you can't say, how does your MS affect your health? What are the impacts of the MS on you? That is an illegal and impermissible inquiry. Again, there are whole seminars on these subjects, but so you just need to know that if an employer wants to ask questions of an employee who has an illness or an injury, you can give them advice about what to say and what to look at. You can look, the EEOC has guidance on these things. They have a whole guidance on the types of questions you can ask and can't ask. And so if you get this question, it would be easy to research or ask someone. Oh, there it is. We've talked about it. I'm going to kind of fly through the FMLA. Let me just ask, does anybody here contemplate representing a nonprofit that will have more than 50 employees? There are a few? Okay, all right. Well, I'll just deal with the FMLA pretty quickly. This is the federal law that allows for 12 weeks of unpaid leave during any 12-month period. In order to be covered, you have to have 50 employees within a 75-mile radius. So that applies to the employer's coverage. In order for an employee to be eligible under the FMLA, they must have worked for the employer for 12 months, and they must have worked at least 1,250 hours within the last 12 months. The 12 months of employment requirement doesn't require that the employment be continuous, but the 12 months and the 1,250 hours requires that it all have been worked within the last 12 months. I'm just going to mention this. It is the bane of employers' existences, the notion of intermittent leave. I don't know if you all have heard of that, but under the FMLA, you don't have to take your 12 weeks all at one time. You can take 6 weeks at a time. You can take 8 weeks at a time, depending on the nature of your condition. And that's all typically pretty easy for an employer to handle. What is problematic is when an employee wants to take what is known as intermittent leave. And that's basically episodic leave that they need because of a condition that might require them to miss work 1 day a week, or might require them to miss work, 5 hours every third day. Migraines, migraines, all that stuff. The problem with it is it's very, very hard to accommodate. And the FMLA does not provide much in the way of a remedy for an employer to accommodate people with FMLA leave who are disrupting the operation of the workplace. So I've had lots of clients be very upset with me for not being able to come up with a solution on how to resolve the problems of intermittent leave. One thing that the regulations allows is that if you have an employee who is on intermittent FMLA leave, you can move them to another position. You can't change their pay, but you can move them to another position that might more easily accommodate the intermittent leave. For example, if you have an employee who is the receptionist at the workplace and she greets everybody and she knows how the phones work and nobody else really does, or maybe there's one other person, and she has intermittent leave and she's got to be gone 2 days a week, that's very difficult for an employer to deal with. If you take that individual, man or woman, and put them in another position as an administrative assistant or in the supply room or someplace else, but you don't change their pay, then that is permitted under the FMLA. Another thing that is, well, I might as well follow the slides. Qualifying leave under the FMLA, you get it for, you get 12 weeks, 26 weeks for military issues, for the birth or placement of a child, i.e. the adoption of a child, to care for an immediate family member, a spouse, a child, or a parent, and there's a definition of immediate family member under the regulations and the statutes, if they have a serious health condition, or for your own serious health condition. There are very technical definitions of serious health conditions under the FMLA. If you have inpatient treatment, if you have to spend the night in the hospital, you're entitled to FMLA leave. If you have a continuing course of treatment that provides a period of or that imposes a period of incapacity for more than 3 consecutive days, then you have a right under the FMLA. If you have pregnancy, you're entitled to it. If you have a chronic condition, if you have a condition that requires permanent treatment, again, if it's temporary, if it's the cold, if you have a cold or the flu or headaches that aren't migraines, those things aren't covered. Cosmetic surgery typically is not covered. Generally speaking, you kind of know it when you see it. You'll recognize if there's an FMLA issue because it's not just your typical run-of-the-mill, somebody's got to miss a day or 2 of work. And under those circumstances, employees are entitled to certain rights. The most significant right under the FMLA is the right to be restored to the same or equivalent job. So if somebody goes out for 12 weeks with a heart attack, you need to put them back in the same position that they held when they left, or an equivalent position. And an equivalent position means the equivalent duties, the same pay, no disruption in benefits. All right, the interplay between the FMLA and the ADA. Most employers think that once the 12 weeks of FMLA leave is up, that they have the right to fire the employee and they have no further obligations because they've provided what federal law requires. The Americans with Disabilities Act, however, imposes a greater obligation, and we talked about it. I usually give people 5 or 6 months, and that's what the courts have said. If you have an individual who is on FMLA for 12 weeks, there's a pretty good chance that that person's going to be covered under the ADA, and then you have a duty to accommodate them by examining whether or not they're entitled to additional unpaid leave. Inevitably, the question is yes, and you need to just kind of go along with the process, monitor the individual's condition, and at some point after 5 months or so, when the employee cannot give you a definite return to work date, then it is safe to end their employment. But unpaid leave is a reasonable accommodation that follows on the heels of FMLA leave. I'm going to skip through all these, which are probably not applicable to you guys anyway. I'm going to mention just the Fair Labor Standards Act, because it is an issue that sometimes arises with respect to nonprofits. There are not any special rules that apply to nonprofits, but one requirement of the Fair Labor Standards Act, which is the law that requires minimum wage and requires overtime if you work over 40 hours a week. And that is important. You must work over 40 hours a week. If somebody is on vacation on a Monday and then they work 12 hours or 10 hours a day, Tuesday, Wednesday, Thursday, Friday, they're not entitled to overtime simply because they worked more than 8 hours a day. You're only entitled to it if you work 40 hours, more than 40 hours a week. In any event, with respect to nonprofits, in order for an employer to be covered under the Fair Labor Standards Act, they have to be an enterprise. And in any kind of retail or service establishment, that means they must have provided or earned $500,000 in revenue. Well, most nonprofits don't do that, although I had a client that provided medical services. So it would have been considered a service establishment, and that $500,000 cap would have applied or would have triggered coverage if they met it. They didn't meet it because they provided all their services for free. But they were sued under the Fair Labor Standards Act, and the question they raised is, well, are we covered or not because we don't earn $500,000 in revenue? But the answer was yes, they were covered, because individual coverage, i.e. not enterprise coverage that applies to the employer, applies to the individual employees if they perform services in interstate commerce, which, as everybody here knows, is an extremely broad test. So if you have an IT person who is receiving goods from out of state, they're covered. If you're sending emails and on telephone calls with people who are out of state, you're covered. So it's going to be the narrow exception where an employee might not be covered under interstate commerce for a nonprofit, but it certainly could happen. Again, you're not given advice based on the exceptions because you want to make sure that your clients comply with the Fair Labor Standards Act. But if claims are raised, that may be something that you want to look at.
Does the $500,000 does not include donations to the nonprofit?
It does not include donations. There are all kinds of exemptions under the Fair Labor Standards Act, white collar exemptions, professional, administrative, executive. You guys are probably familiar with that. One pointer that I do want to mention though is, again, the overtime requirements only apply to non-exempt employees. Only apply to non-exempt employees. That is, employees who typically don't have the discretion to perform executive functions, administrative functions like head of HR. It is not enough to evade the Fair Labor Standards Act simply because you pay an employee a salary. Employers often think that if they pay an employee a salary, i.e. not hourly, and they pay them the same set amount each week regardless of the amount of hours they work, that they're exempt from the Fair Labor Standards Act and they don't have to pay overtime. That is not true. You determine whether an employee is covered under the Fair Labor Standards Act by looking at, one, if they're paid on a salary basis, and then two, if they perform the duties that are significantly critical to the organization and that they have sufficient discretion to be considered exempt. They also have to be paid a certain salary level, but it's $455 a week. That's easily met. So I've gone over. Thank you. I'm now going to turn it over to Sam.
Wow, okay. Which one? This?
Oh, yeah, let me click through for you.
Okay. Back one. Okay, great, thanks. Okay, so David gave you a great broad overview of all the relevant laws applicable to employees and employers. I'm going to sort of do a little bit of a deeper dive on some of the issues that come up on a day-to-day basis with employers and nonprofits. I did want to talk just in general about nonprofits as clients. I'm sure all of you have worked with nonprofits. You've probably served on boards, been involved in some way, shape, or form, maybe been employed. You'd probably agree that in the private world, in the private sector, the question's asked, what have you done for me lately? In the nonprofit sector, it's what have you done for the mission lately? Very mission focused, very committed labor force. Oftentimes you have a very small working group who have been together for a long period of time. All of these issues can contribute to employment problems. If you have 2 or 3 people who founded the nonprofit, have been working together for years, usually things go swimmingly well, but when they go bad, they go very, very bad. Like I said, very mission focused. That can often lead to a lack of oversight of employees. When everything, I took a year off in between college and law school and worked at a nonprofit in Norfolk. And I was amazed at how everything was, I was a 22-year-old self-centered person, but at how everything was for the children. Did you make too many copies because that impacts the children? Did you do this because that can benefit the children? It was a real learning experience for me because it was very different from what you see in the private sector world. But it often takes supervisors and managers in nonprofits, takes their focus away from actually overseeing employees. So when you come into a nonprofit, you should be looking at what they have been doing in the past to manage employees. Look at their policies, their handbooks, their, how they handle discipline, etc. All those are questions that you're going to have to delve into if and when an employment issue comes up. There's something called the founder syndrome, where the founder of the nonprofit often thinks he or she owns the nonprofit. No one owns a nonprofit. And he or she needs to understand that there are other factors that control the mission, that control the path of the nonprofit, the growth, etc. This can be also potentially problematic when the founder is overseeing employees and has a very distinct personality, a strong personality. I've had a number of issues come up where the founder is, all about the mission, which is great, but this is the way we do it here. And they might hire an executive director who might want to do it differently, and you have very commonly you have a clash of personalities. So you kind of need to be prepared to walk the client through that, the best procedure, the best process, etc. That is something that comes up often. Employment classifications are a big issue for nonprofits. Is the person an employee, a volunteer, an intern, an independent contractor? I'm going to talk about volunteers and interns because those are 2 big issues that should probably come up for you guys, even if the nonprofit doesn't bring them up. Independent contractors we haven't really talked about, but I will just tell you that that's a huge issue. The IRS is all over the independent contractor issue lately. And if the worker is doing anything that is devoted to the core operations of the nonprofit, and the nonprofit has some significant or substantial control over that worker, I will tell you that they are most likely an employee, not an independent contractor. Regardless of if they sign an independent contractor agreement, people sign these and think that's the end all and be all. That's not even the beginning of the analysis. So take, for example, one nonprofit I work with, they have a marketing person, an outside marketing person. Now that marketing person has her own business, works with other clients. This nonprofit is not the only one she services. That's more likely an independent contractor because the nonprofit doesn't have internally any marketing department. So they rely solely on her for that really discrete set of skills. versus a larger nonprofit that has an internal marketing department that uses an outside marketer, and that outside marketer works full-time for that nonprofit, doesn't have any other clients, says, I'll work for you from 9 a.m. to 5 p.m., I'll abide by your policies, et cetera, et cetera. More often, that person will be an employee of the nonprofit. So keep that in mind when you're looking at the people that work for the nonprofit. Oh, sorry. Volunteers. This is a huge issue with nonprofits because everybody has them. They really rely on them. There's actually currently a nonprofit that works with nonprofits on volunteers and on maximizing their volunteer contributions, which is a phenomenal program, by the way. But anyway, an employee is defined by the Department of Labor as one who an employer suffers or permits to work. That's the definition of employee. A volunteer is one who performs hours of service for civic, charitable, or humanitarian reasons without promise, expectation, or receipt of compensation for services rendered. When you think of a volunteer, you think of somebody who's doing this solely for their personal fulfillment. If the nonprofit is relying on the volunteer to do their job, you're in a problematic area, and you need to analyze that relationship a little bit better because it might be that they're an employee. These are the factors that the Department of Labor will look at to determine whether or not it's a true volunteer relationship. And if it is, then the volunteer is outside of the Fair Labor Standards Act and does not need to be paid minimum wage, overtime, etc. Not one of these factors is determinative of the other, of the analysis. It's a totality of the circumstances kind of approach. A lot of times where you get into problems is paid employees often want to volunteer for the nonprofit. You have the HR person who says, hey, there's a picnic this weekend, I'd love to come help. That's usually okay. But when those situations arise, just do a little bit of a deeper analysis into, okay, what is the person actually doing when they volunteer? If that paid employee is actually still performing the services they provide to the nonprofit during the volunteer time, that's paid time and you have to pay them for it. If the paid employee is required to attend a weekend event, which happens a lot with nonprofits, and it's not something that they necessarily would have attended of their own accord or their own agreement, then that is paid time, and if they're an hourly employee, you have to pay them for the time that they showed up. So there are all these overlap issues that occur with volunteers, and it's just important to keep it in mind. I've got another nonprofit that I've worked with that has an after-school daycare facility, and they have paid employees working at the facility. They also have parent volunteers who have agreed to come in every day from 3 to 6. If they don't come in, there are ramifications. They have to abide by the nonprofit's policies while they're there. They have to do a background check, which is not necessarily determinative, but basically they are doing exactly what paid employees are doing for the nonprofit. That, and I told them this, and they're not always going to listen to you. So your job is to give them kind of a risk analysis advice. Those volunteers most likely would be determined to be employees, and you may have to pay them back pay if they ever made a claim for services rendered. Some risk management tips when it comes to volunteers. Put it in writing, have written job descriptions, and this is kind of a initial analysis that you might want to do with your nonprofits too. Ask them if they have job descriptions for their employees. If they don't, that's certainly something that you can oversee without help from clearinghouse, etc. What I tell my clients with job descriptions is have the employee who you're writing the job description for contribute to the job description because they're the ones who know what they do on a day-to-day basis. Analyze and reevaluate the job descriptions every year. Have a volunteer job description as well. It depends, for like the Children's Museum, they have volunteers on all levels. So there will be a number of different job descriptions for volunteers that you would write. And it would be more of this is what you're going to be doing, no requirements. You also want to make sure in that volunteer job description you understand there's no compensation provided for services rendered. That sort of goes throughout the conversation about volunteer. Have 2 handbooks. Have an employee handbook and a volunteer handbook. make sure that there's very little overlap between the two. The volunteer handbook is just sort of like, here's what's available, here's what you're going to be doing in these various volunteer positions. There's no compensation for the services that you're rendering, and obviously the employee handbook is going to have all the regulations, the Title VII sexual harassment policy if it applies, attendance, dress code, etc. That shouldn't be the same for volunteer handbook. The only overlap should really be if there are safety issues on premises of the nonprofit. Those should apply to volunteers as they do to employees. Never ignore off-the-clock work. Like I was talking about paid employees, if they're volunteering for you, make sure it's true volunteer service. A lot of these hourly employees, we've seen it a lot in the private sector with Walmart, et cetera, Dollar Tree, or Dollar Store, Dollar General maybe. Dollar General. Oh, yes, all of them. Sign out and then continue to work. A lot of employees at nonprofits are willing to do that. They want to give 110% to the mission and don't want to take anything away. So they will easily clock out and either go to an event that they're required to attend or continue to work off the clock. So be really aware of that, because that can bring about serious Fair Labor Standards Act issues that you don't want to have hit you. And never force paid employees to attend any event. It should be purely voluntary, unless you intend to pay them. Interns and trainees, this is a little bit different from volunteers. Like I said, volunteers was purely about personal fulfillment. Interns and trainees is about educational improvement. Who is benefiting in a true intern-trainee relationship? Only the intern should be benefiting. In fact, the nonprofit should be burdened by it almost. What I tell my clients who are looking at an internship, the best way to ensure that an internship will be outside of the Fair Labor Standards Act employee relationship is to get credit for it, to work with a university or a high school that says, hey, this is a seminar within our school, we're going to allow them to work. Children's Museum has something like that. We're going to allow them to work there 2 days, volunteer 2 days a week, or intern 2 days a week. They get rotated throughout the different aspects of the nonprofit. They learn about fundraising, they learn about marketing, they learn about safety, they learn about training, etc. So it really should be a burden on the nonprofit to have a true intern. Does that make sense? A burden in a good way. You're really educating them about how the nonprofit is run and teaching them a different set of skills than they otherwise would have had. If they are doing the job that paid employees are doing for the nonprofit, they're more likely to be determined to be an employee and eligible for wages. At-will employment, thankfully, is alive and well in Virginia. A lot of people confuse at-will with right-to-work state. At-will is the idea that a person is not guaranteed employment for any length of time, and that either the employer or the employee can terminate employment at any time for any lawful reason with reasonable notice. And I'll get into reasonable notice in a little bit. There are some statutory exceptions. You can't fire an employee solely because they filed a workers' comp claim. Solely because has been determined to be a but-for analysis, so it's a pretty difficult claim to win, but like David was saying, when someone's ready to be terminated, if they've recently filed a workers' comp claim, you might want to look a little more deeply into the basis for termination. If you have any employment documents, and I'll get into those, offer letters, policies and procedures, even an employment agreement, maybe with a higher level employee, always have the at-will disclaimer in there if that's what you intend. You might intend for an executive director or CEO to have a certain period of employment, 1 year, and it redoes every year or 2 years with a 1-year renewal, etc. If that's the case, the at-will employment disclaimer will not go in there, but you should have it in your policies and procedures and in any offer letters that you present to an at-will employee. Common law public policy, wrongful discharge claims. I wouldn't worry so much about those. There is a claim in Virginia for wrongful discharge based on public policy. It's very difficult to prove and has to be linked to a specific statute designed to protect that employee. I'll just say that, if you have a nonprofit and they're ready to terminate somebody who has made some complaints about the way they're running their business or maybe collecting federal funds, et cetera, then you might want to call the clearinghouse and do a deeper dive into, again, the basis for termination. But I don't think it's necessarily something that you need to worry too much about. Oh, I'm sorry, I'm forgetting to skip. Offer letters, employment agreements, these are, it's just really nice to have a lot of documentation when you're working with any employer, whether it be a nonprofit or private employer. So if they do have offer letters, when you initiate your relationship with them, ask to see all their employment records and see what kind of shape they're in. A lot of these nonprofits say, oh, I have a great contract I got online. And it's horrible in Virginia. It has a lot of things that violate the law. So definitely look at all their employment documents that they use, particularly their offer letters, because the offer letters are the initial conversation with the employee. And they can obligate the nonprofit to things they weren't intending to be obligated to. So look at all those when you start working with them. Employment agreements should really only be used for higher level employees. When you want to set very defined, like the term of employment, the way to terminate, you want them to give you 30 days notice, particularly if it's an executive director, or at least 60 days notice. One thing I will say is that usually those notice terminations are mutual. So either the executive director or the nonprofit can terminate with 60 days notice. What I like to include in there is the nonprofit, if something has gone sour, the nonprofit has the right to terminate but make termination effective immediately and pay the executive director for that notice period, because that gets them out the door. You don't necessarily want somebody in there you've terminated who's going to be disparaging the nonprofit or not treating employees correctly or just being in a bad mood and a cancer to the nonprofit. So that's a nice term to have in there. You don't have to exercise it. Background checks. You're going to be, a lot of these nonprofits their mission is focused on the particularly vulnerable, the elderly, children, abused, etc. I had to serve on the Children's Museum board, I had to go through a background check because I could certainly have interactions with children on the floor, etc. Every volunteer, every employee at Seymour has to do that. Look and see if what kind of mission your nonprofit is focused on. If it does entail working with the elderly, going into people's homes, etc., working with children, you do want to see what kind of background check provisions that the nonprofit has. A private employer certainly can require employees and volunteers to go through a background check. There's a ban the box, you probably all have heard of that. That was passed recently. That applies mostly, and that's basically just saying take that little box that's on the application for public entities off the application. That doesn't mean that public entities don't do background checks anymore, but there are restrictions to them. And generally, if they do them after an offer of employment has been given. McAuliffe, said, hey, private employers, you guys should do this too. Not many people have followed suit with taking the box off the application, the check box. So I just put that in there. It doesn't necessarily apply to most private nonprofits, but something to think about, and they might ask you about ban the box, aren't we? Isn't it illegal to put that on there? No, it's not necessarily. You cannot require the disclosure of expunged arrest or juvenile records. And in fact, I generally tell my employer clients, you don't necessarily even ask about arrests, just ask about convictions if you're going to ask at all. So there are two things we're talking about. On the application, you can say, have you ever been convicted of a felony or misdemeanor outside of traffic violations? And that's on the application, and they fill that out. The next thing is, are you going to follow up with asking for a criminal background check? If you do that, You have to get consent, and there's a very thorough paragraph that you have them sign. It needs to be separate from the application. Very clear that, hey, by signing this, we're going to do a background check, and you might not be hired if the results are unfavorable. So those are two different things. But you certainly can go forward with background checks for really any and all employees. One thing to keep in mind is the Fair Credit Reporting Act. Under the Fair Credit Reporting Act, if an employer, and most employers who do background checks use an outside agency to do them, they're called a consumer reporting agency. If you do that, then you have to clearly notify the employee about the check in writing, which you would do anyway, even if you did it yourself. Get written consent, which you would do anyway if you did it yourself. However, the third thing is you have to provide the employee with a copy of the report and a summary of their rights to contest the report before you take an adverse action. So if you use a consumer reporting agency and you send in Joe's social security number and they say back, hey, Joe was recently arrested or was convicted rather of embezzlement, felony embezzlement, and you say, well, then I'm not going to hire him to do the accounting for my nonprofit. You have to send Joe a letter saying, here were the results, here's the report, and there's a form that the Fair Credit Reporting Act has online that has a summary of Joe's rights. He can contest it, he can call the Consumer Reporting Agency, or most likely if it was done right, he's not going to do anything because the conviction stands, and that's certainly a barrier crime to an accounting job. But you have to follow through all those steps if you use a third-party reporting agency. Make sure if your nonprofit has what I just referred to as barrier crimes, like, hey, we're not gonna hire anybody with any conviction in the past 20 years. You want to look into that a little bit more. In fact, the EEOC, while they're not binding and generally their recommendations are just advisory, it's not a bad practice to do an individualized assessment, and this is not that difficult for nonprofits when they're not huge. It's very difficult for employers with thousands of employees, but for nonprofits, do an individualized assessment. How old is the conviction? What is the conviction? How much does it relate to the job I'm asking this employee to perform? If you do that, then it's much less likely that an employee is going to claim that you didn't hire him or her for some unlawful reason under Title VII. Because the EEOC has basically said, if you don't hire anybody for any conviction or you look at only arrest, there could be a disparate impact on the people who are affected by your policy. So just if you do an individualized assessment, a reasonable analysis of the convictions that you see, then you're in a much better position to defend your actions. Personnel files, just briefly, they don't belong to the employee. I get this question all the time. Employee fired, they want their personnel file. Tough. You can't have it after they're terminated. While they're employed, a good practice is to allow them to look at it, review it if they want in the presence of a supervisor, but not have copies. Another thing is that David was talking about the Americans with Disabilities Act and the interactive process. If you have health information from employees, you should keep it separately under lock and key, separate from their personnel file, under lock and key, because it's obviously highly confidential information and you don't want other employees to have access to it. Briefly, you can put negative information. A lot of HR people are terrified to put anything negative in an employee's file. If it's factual and not opinion, and it is based on the employee's actions while employed, then you have to put it in their personnel file because you have to have documentation of an employee's performance, particularly if it ever comes to a termination issue. But that's just something that some HR people are terrified to do. Working time, just remember what David said for non-exempt employees, hourly employees, any hour worked, you have to pay them. You can require employees to work weekends. Be wary of religious accommodations. That's still out there alive and well. If they ask for a religious day off. You have to do an analysis as to whether or not it's allowable if you've done it in the past, if it's an undue burden on the nonprofit, and that's an analysis that should be made probably by an employment attorney, then you can deny them the day off, but that's not something to be taken lightly. You don't need to provide lunch or rest breaks in Virginia for people over 16. A lot of people think, I get my 1 hour lunch. You don't. But if you work during your 1 hour lunch, you get paid. You don't need to pay employees for lunch breaks, for breaks really over 30 minutes. But just keep in mind what I said, keep in mind or always have an eye for off the clock work. There are a lot of nonprofit employees, private sector employees, who will say, okay, I take lunch from 12 to 1, but I sit at my desk and I really just do filing or I do dictation. If that's the case, they're working, regardless of if they're eating a sandwich, and they need to be paid for that time. So that's another issue of off-the-clock work. Electronic usage and social media. Just keep in mind that you can't require applicants or employees to give you their passwords. It happens, it used to happen a lot. Now there's a Virginia Code section prohibiting employers from requiring employees to provide that information. Also keep in mind that you should have a social media policy which talks about expectations in the workplace, both from posting standpoint but also usage standpoint of the nonprofit's computers, etc. Also keep in mind that employers often look at social media they check out applicants. Be prepared for what you find. It's not uncommon to go onto an applicant's social media site and see that they have a disability or that they have a certain political leaning or certain religion. And are you going to want to make a decision? You can't unsee it. So just know that you're getting into that when you do a social media search. Termination issues. Reasonable notice I talked about earlier, that has finally been determined by the Supreme Court. The lower courts were oscillating back and forth on what is reasonable notice. Is it 2 weeks? Is it a month? Does it exist? Or can employers just fire without any notice? The Supreme Court a year ago, determined that reasonable notice means the quality and manner of the notice, not the timing. So you can certainly terminate employees immediately. You just have to say you're being terminated. So they know that they're being terminated. That's reasonable notice. So that's when management employers did a happy dance because it just resolved that issue. Get a release. There's no requirement for severance unless the nonprofit always gave it. Like I was talking about earlier with precedent, they say we're firing Joe. He wants severance. We don't want to give it to him because he's been a pain in the butt. Okay, would you give other employees severance? Oh yeah, we always give employees 2 weeks severance. Well, why aren't you giving Joe severance? If you have an established policy, written or practice, unwritten, of giving 2 weeks severance, you basically need to give severance for every terminated employee. You can change that practice or policy, but just be aware that that might be out there, that precedent. Another thing is if I've had this issue in the handbook, in the employee handbook, if it says if you give us, let's just say if you're terminated other than for cause, we'll give you 2 weeks notice, 2 weeks severance. If that's in the handbook and you terminate somebody and give them 2 weeks severance, you can ask for a release, but the release won't have sufficient consideration to be enforced because they are not getting consideration above and beyond something to which they are entitled. So if you have something in the policy handbook or the personnel handbook saying we will give X amount of severance, then either take it out or say upon the endorsement of a release to be given to the employee at the time of termination. So there's an expectation that severance isn't just going to be granted, that you do have to sign a release. So that's just something that's come up. Upon termination, some questions to ask when they call you and say, I want to terminate Joe. Has Joe complained about payroll recently? Have they made any complaints about the way they've been treated? Have they requested overtime? Taken medical leave recently? Do they have a medical condition? Do they have a disability? Why are you terminating them? If it's for disciplinary reasons, do you have documentation? These are all questions that you need to sort of go through like you're cross-examining your client about the employee, which will give you the sense for, okay, what are we dealing with here? And are there any problematic issues? And then just briefly, kind of in that same vein, you all know that the clearinghouse exists for issues that can be disseminated to more specialized attorneys. I would suggest to you that if you get the following issues, you consider calling the clearinghouse if it doesn't look like something that you can handle. A request for an ADA accommodation. That's a very specific process that the employer and the employee need to go through. The interactive process is really dicey for the employer because the employer has to ask about health information, which makes them nauseated to even go into. That's something that can really help, an employment attorney can really help them with. And an age discrimination release, if they do not have one, like David was talking about under the Older Workers Benefit Protection Act, we have forms. It'll take us 5 minutes to give them the form. If you see that they don't have a proper release mentioning the Older Workers Benefit Protection Act and the person being terminated is over 40, then I would call the clearinghouse to get that release unless someone in your firm has that form. Sexual harassment allegations, that's probably something that you should get the clearinghouse involved in. Or threats of violence. If an EEOC charge is filed, you also might want to call because then an employment attorney can step in and file the position statement on behalf of the nonprofit. Request for FMLA leave, if you do represent a nonprofit with over 50 employees and they don't have the appropriate FMLA documentation, there are forms that the Department of Labor has. If they don't have a good packet, and haven't done it very often, then you might want, at least initially, to have someone go to the clearinghouse so they get that initial documentation all planned and prepared for them. And finally, any Fair Labor Standards Act classification issue. If you see they have volunteer issues where they're mandating time periods of work, etc., following policies, exempt, non-exempt, they're not paying overtime to people who seem to be hourly, then I would also engage the clearinghouse for that. Okay. Any questions? Sorry, I really flew through that because you didn't give me much. Do y'all have questions about what we talked about? It's a lot.
Okay.
Wow, must have been thorough.
Thank you.
Okay, thanks, guys. Oh, Allie, hold on.
I didn't mean to cut off the applause. You can keep doing that. They deserve it. That was excellent. All right, a couple of housekeeping. First of all, in the beginning I said November 16th. It's actually November 15th. It's Wednesday. We're trying to keep on Wednesdays for your training. Also, as you heard Sam mention a couple times, referral to the clearinghouse, that's really what we're expecting you to do unless you are an employment lawyer. If she's done a great job of kind of really giving you some hands-on issues and what you would do in the situation, and of course that's great for you to know, but you can't probably learn in an hour or 2 hours on how to handle these. And we're looking at general counsel as literally an issue spotter. And then if you feel comfortable and you want to take it the step further and provide the legal advice and do the work for them, you may, or you can send it to the clearinghouse. We're also going to have a mentorship level of volunteers to help you on specific issues. We have that good counsel book that we plan on providing in some fashion to all the ones that get matched with a nonprofit. And there's a great chapter called Getting Personnel, with all the questions that you can ask yourself, the nonprofit, on are these things in place. And I think what both Sam and David have allowed you to see is that there are a lot of areas that could be potentially intersected with volunteers, with staff, and we don't expect you to now go forth and be an employment lawyer. But we do hope that you will use these materials to kind of get to a starting point. CLE, I know everyone loves CLE credits. So the last training and this training, we're still waiting from MCLE to get the course number. As you know, as long as you take the course before October 31st, it still counts. It doesn't matter if they actually provide us the course number later than October 31st, which will probably be the case because there's probably 1 million CLEs going on in October. So, but we appreciate your patience on that and hope to see all of you on October 25th. Thank you very much, Sam and David.
Thanks.